Hi, my name is Mike Solomon, and welcome to a webinar presented by the law firm of Solomon, Steiner Peck. We have 3 offices, one located in Mayfield Heights, one in Independence, and one in Westlake. Any of those offices, we meet with you and be glad to discuss your issues. If you have any questions, please give us a call at 216-765-0123, and later on at the end of the seminar, we'll give you more of our contact information. Thank you for watching.
Hi, I'm Steiner Peck, and today I'm going to be discussing healthcare powers of attorney and living will declarations. Age, illness, and incapacity often cause us to have to rely on others to help make medical decisions and also financial decisions. A guardianship is essentially a court-supervised event when an individual, referred to as the ward, is declared legally to be incompetent. It requires this legal determination, and it is public record. So let's say we have an individual who's 85 and has begun to lose her competency. Her name is Sally, and she needs assistance making medical decisions. If she hasn't signed a healthcare power of attorney, then she may need a guardianship where a court will appoint a suitable person to serve as her guardian to help her make these decisions. But if Sally wants to avoid this, before she becomes incompetent, she can execute something called a healthcare power of attorney. I'm going to start with a couple of definitions on healthcare powers of attorney. The first is the attorney in fact or agent. They are used interchangeably in the document. This person is the person that Sally is nominating to make medical decisions in the event that she becomes incapacitated. The person making the document, Sally, can limit the authorities of the agent, but essentially the authorities of the agent include the ability to consent to medical treatment, to consent to surgery, to consent or refuse to any health care treatment, to hire medical personnel or fire them, and to contract for admission or discharge from any medical health facility. So let's say that Sally has decided to appoint Tom as her healthcare agent, and she executes the document, and then she says, Tom, why don't you come with me to the doctor's? At the physician's office, the physician recommends certain treatment, and Sally decides she doesn't want to follow that course of treatment. But Tom, who's there with her, thinks it should be something that Sally consents to. So he says to the doctor, I do want to consent to the treatment. The question is, because Sally's executed this health care document, does that mean that Tom can have the authority to make these decisions? The answer is no, which brings up, when can a healthcare power of attorney become ineffective? Essentially, the healthcare power of attorney comes into being upon execution and when the principal making it is determined to be incapacitated. However, if Sally appoints Tom and then later decides this is a bad decision, a healthcare power of attorney can be terminated by the principal by simply revoking the document. Now, the healthcare power of attorney can be executed by anyone in the state of Ohio who is an adult and also competent at the time. And they can appoint pretty much any other competent adult to serve in that capacity. They don't have to appoint a related party. However, they can't appoint their attending physician, a nursing home administrator, or an employee of either the attending physician or nursing home unless they're somehow related to them by blood, marriage, or adoption, or being in the same religious order. In addition to a healthcare power of attorney, there's also something referred to as a living will. It's a document by which the declarant can make a determination and direct his or her treating physician when to withdraw, discontinue, or even not begin life-sustaining treatment if they're terminally ill or permanently unconscious. So before this event occurs, the declarant is making his or her intention clear. And this document is different from the healthcare power in that it's actually stating the principal's intention rather than just giving the agent the authority to make these determinations. Similar to the healthcare power of attorney, Sally can pre-indicate whether she wants that life-sustaining treatment that's withdrawn or withheld to include artificial nutrition and hydration. The healthcare power of attorney and living will declaration can help us have someone there who can make medical decisions when we can't, and also can speak for us when we can't.
Well, thank you for watching our seminars on estate planning. I hope you found these topics useful. If you'd like any more information about this, you can certainly give our office a call at 216-765-0123 or go to our website and email a request to have a personal planning appointment. Contact us and we'd be glad to help you. Thank you very much.